process with DEP when permits are issued.
No, I understand, but if there's a
So we
provision
have to
here,
make sure we get it right on the local level.
if there's a provision in here that says you must comply with all the state and federal laws and stuff like that, I mean, obviously we have to do that, I mean, that's not an issue. But if you start specifically setting forth
But if
which
you
ones
have
you do and
a
don't,
permit
that's a
with
problem.
DEP, you can start drilling because there's no appeal process. And damage is done before, it gets rectified on the state level through civil litigation or whatever. See what I'm saying?
I understand, but we're not here to talk about the DEP process, we're here to talk
Well,
about.
we're talking about getting it right because the DEP has made it very clear with that, in September when they had the West Virginia Supreme Court of Appeals for the Hamlet case, that landowners don't have a right to appeal a permit. So you're saying, oh, don't worry about this, DEP has it covered, they're not going to allow it. But if they accidentally do, then we don't have an appeal process for the permit, which means we have no protection. So if it can be worded in this, maybe it should be.
I'm not saying that, I'm saying that it's fair for an ordinance to suggest that you have to comply with other laws, both state and federal, or local laws.
Right, but it puts the burden on the surface owners, the citizens, the residents, to have to pursue it if DEP fails to do what they should, whereas we could solve it on the local level.
Well,
What I'm
FEMA,
suggesting
Your point's well taken. You could solve it as it relates to the floodplain.
Right.
Yeah. Your point's well taken.
Thank you.
if you would look over on page 34 of the ordinance, it's item number 1. It says, after the filing of an application for a permit and receiving a properly and time filed objection, but prior to the administrator's decision to grant or deny, the administrator may, in his whole sole discretion, hold a public meeting wherein evidence can be taken or given by interested persons or parties. Instead of may, in his whole sole discretion, shouldn't that be shall? Aren't we entitled to a comment?
Yeah, not really. To be honest with you, I mean, this provision was drafted anew by me, and it anticipated the difficulty that that a floodplain administrator could run into, and that is that he wants to hear more. So when you put shall, then he has to have it in every case. Well, he may not need to hear more based upon the written objections and what has been filed.
What somebody's building residence in the floodplain, adhering to everything here, do we have to have a public meeting where all the neighbors can complain or whatever? Is it mandatory?
Okay.
Yeah, and so I mean,
So, there has to be some discretion there.
Okay.
If it looks like it will, yeah.
That's what I'm saying, we're talking.
And if it does, yeah, we have it. But if it's a cut and day dry case where it's not going to affect anybody else, we have to have a meeting for that. I don't think
Who
so.
makes the decision? That's what I'm saying.
I don't like the term sole discretion.
Yeah.
No, I didn't like
I mean,
it.
it's his job to review the permit process, and whose discretion should it be in? If you don't like his decision, you can appeal to the appeals board and have your hearing. I mean, that's why those provisions are in there.
I mean, ultimately, in all governmental settings, someone's got to make a decision. And if your floodplain administrator makes decisions that you don't like as the public, as the voting public, your opportunity is that all three of these commissioners sit for re-election. And they appoint the floodplain administrator. So the mechanism of government sometimes is that you have to politic to process who's going to be a commissioner as to who's going to be the floodplain administrator. So that's how you control sole discretion.
I need you to explain the paragraph on page 37. It's paragraph B. It says, send each property owner except the floodplain permit application location owner. What does that mean? You're going to send each owner?
The floodplain permit application person will know of the permit being applied for. I mean,
What they're saying is they don't have, if EQT applies for a floodplain permit, they don't have to send EQT a copy, we'll have a copy.
yeah.
But this paragraph says that you're gonna send each property owner and the adjacent property owners. And you're not gonna send one to the location owner. That's the way this is.
The
phrased.
floodplain permit application location owner. I'll have to review
It's
this.
just, you can revise it and say the
Oh,
applicant.
well, I'm big wish.
Yeah.
You can fix that revising the applicant, you know, that's what it's.
Yeah, except floodplain applicant.
No,
Does that
because they
clarify
said,
for you?
well, no, it didn't have to be
Yeah.
adjacent, it had to be the people, even if it
In-
didn't
within
join
the
in
flood-
effect. So it would
floodplain.
meet that.
So if anybody here is going to apply for a floodplain permit, make a copy. They're not going to send you one.
Again, on page 39, your stop work orders, I think that was a typo. I think you meant section 8.4 for the penalty.
That is correct,
Okay.
because we changed 8.3 to 8.4 at one point. I thought we got
Or
numbers.
something.
On page 40, section B, where you're discussing the inspections and revocations, item number 2, don't you need some sort of a sentence that explains what the notification process is going to be? Is it going to be certified mail, registered mail, telephone call? Don't you need some sort of a sentence? You said that the administrator will notify, but don't you need an explanation of how this notification is going to take place? It was just a thought. I know EQT complained before because they said they didn't get notified. So maybe we should have a sentence in here that says how the person's
I
involved.
believe that's covered under administration in the national book and Cleveland and everything there, as to how that's supposed to, it's recommended how it's supposed to be done.
Okay. The last, and this one I would have addressed to Mr. Sneed. On the bottom of page 40, section 7.8, where it has to do with certificate of compliance. The wording has been changed here. Now it says, nearly every paragraph says areas of the floodplain. The original ordinance used the phrasing areas of flood hazard or flood hazard areas. And by definition in the FEMA book, a flood hazard area is not necessarily in the floodplain. It could be outside the floodplain. It could be an area that's subject to mudslides or... So I was just wondering why we did away with the word flood hazard area and substituted floodplain. But nearly every paragraph, A, B, and C, and D, all use in areas of the floodplain now.
That was probably something that I did. And I will go back and look at whether we define flood hazard and look at the definition
Okay.
of,
And I gave you the
flood hazard.
website there where FEMA defines flood hazard.
yeah, thank you. I'll look at that. I was probably attempting to arrive at some consistency between the use of floodplain and flood hazard, and flood hazard wasn't defined in the original ordinance.
And I hate to bring this one up again, but Mr. Hastings has already discussed the fees on section 7.9, paragraph C, where you're talking about doubled and tripled, etc. Wouldn't it just be simpler to say that if work is begun and a permit has not been granted, then that whatever work has been done will just be declared a nuisance and abated? And I mean, why go through all this double and triple thing? Why can't you just say,
Straight out of FEMA again.
straight out of FEMA
Yeah,
again?
that's in the original one right there, that one triple, yeah.
That is in the original ordinance.
That's the original one.
And Joey, it also ignores the opportunity for someone to come in compliance. So someone could, instead of just considering a nuisance, like JB, for instance, and I'm not here to defend JB or say anything about JB one way or another, but in that scenario, they got to stop working with it. They want to get a floodplain permit. They tried to get one, I think, or they contacted Mr. Wellens to
They
do
said
so,
applied for one now.
and now they can't. So they're trying to, if they were wrong in the beginning, they're trying to do it the right way now, so that would ignore that. It gives everybody an opportunity, not just.
Actually, the new wells they have permitted for that are out of compliance with the new rules and regulations on spacing from water wells and dwellings.
Well, that's a whole different question. That's a whole different issue.
It's all part of it. But it shows the compliance problem.
We're here at the floodplain, not you. I'm not saying I'm not concerned.
Permits if they're not in compliance?
What?
Doesn't the DEP say that they're not supposed to get new permits if they?
They got 3
if they
additional
haven't
permits
made
for
it
that
or
same
whatever?
location.
That's between JB and DEP.
Issues?
Mrs. Huff, it smells like they're getting close.
On, Mr. Tennant, on Article 8, the appeals and penalties. Should there be a statement that in case an appeal is filed, that the floodplain administrator would then issue a stop work notice that would remain in effect until a resolution
That's
has
in there.
come
I
about?
believe that's in here.
Okay.
But I mean, I agree with the concept. I think it is in here.
I think it's nice too. I think we actually suggest the language on that.
On the appeal hearings, there's a great deal, 8.2, there's several things in there that I really don't like, but the appeal hearing shall be a hearing wherein all evidence shall be taken anew. You're getting into the whole de novo thing again, right? Isn't it the appeal hearing where all the evidence is just going to be reconsidered?
Well, it's up to the commission. It's not up to me. There's two ways to do it. You either, for example, the Board of Equalization Review, there is no new evidence that's presented at the circuit court level on appeal. I don't have a dog in the fight. I heard here earlier that residents were concerned that they might show up at the appeals hearing without an attorney, they might get over-muscled, and they wanted another attempt at the circuit court level to perhaps bring in new evidence that they didn't think of or weren't prepared to bring forward. So this goes either way. I don't really, for me, you know, when you say that it should just be reconsidered, then you're stuck with what you did below. And if you're, you know, I will tell you that the Commission and the Board of Equalization Review has the upper hand to win at the circuit court level under that standard, because many people come into the Board of Equalization Review unprepared, not understanding what to do, and they don't have a lawyer, and then they're stuck with a bad transcript. So, you know, you really have to judge this, and this is really a political decision the Commission has to make. It's not for me to make, it's whatever y'all want. When I say y'all, I mean the Commission.
I also disagree with the paragraph C where it states the floodplain administrator's decision to grant or deny the permit was clearly wrong. I don't think that should be the goal or what we're trying to prove in an appeal. I think what needs to be proven by whomever is the appealing person, they have to just prove that that development or that structure is not going to cause any adverse effect. It's not. I just disagree with the wording of saying that the floodplain administrator was clearly wrong. I think the burden of proof, if I'm the appeal person, then I just have to prove that what I want to build out in the floodplain isn't going to cause any adverse effect.
Yeah, there's
Politically correct way to say it.
well, anytime you get into an appeal situation, I mean, the odd thing about this is, for 150 years or so, until Justice Cleckley took his seat at the Supreme Court, you could read years and years of law in West Virginia and not know what what's called the standard of review. What is the standard that the court used? Well, for 150 years, they just willy-nilly decided these issues on a case-by-case basis, and no one knew what the standard was until Justice Cleckley went up there, and on every case he decided, the first paragraph was, the standard of review for this case is. And it put into our law consistency that that anyone that's litigating knows what the hurdle is. This is the hurdle you have to jump. So what we're striving for here, and it doesn't matter what the hurdle is, there has to be a hurdle here. So it's either by preponderance of the evidence, it could be by clear and convincing evidence, it could be this language clearly wrong is similar to the Board of Equalization and Review, where you have to prove that the assessor's assessment was clearly wrong. And that's where that came from. It can be whatever the commission decides it to be.
Well, my last 2 pages, again, go back to what we talked about before. The phrase floodplain area has been substituted for flood hazard.